If a person wants to make a will and they're married, they can't make a will which completely excludes their spouse, because if they have children, their spouse is legally entitled to 1/3 of the estate. And if they have no children, the surviving spouse has a legal entitlement to half the estate. Now, if the estate includes a family home or a dwelling house, the surviving spouse is entitled to claim that as part of their 1/3 or one right share. You don't have to go to court. The surviving spouse doesn't have to go to court to get those to avail themselves of those rights. The executor has a legal obligation to make the provision, whether it be 1/3 or 1/2, in favour of the surviving spouse. If a person decides to make a will and excludes one or more of his children or her children, that may stand. On the other hand, there's a section there's a law which states that any one of those children who feel they haven't been properly provided for can come back and make a claim against the estate. Now, they would have to prove that they weren't properly provided for, and if the person who died gave them money or made some advancement to them or gave them some other benefit before his or her death, that's counted. That'll be taken into account. But nevertheless, there is that right there, so people would want to bear that in mind when they're actually making a will. A lot of the problems in relation to inheriting property arise when somebody dies without a will. And if somebody dies without a will, the legal expression is that they've died intestate. Now, if somebody dies without making a will and they're married with children, first of all, if they're married and have no children, their spouse is entitled to the entire estate by law. If they die without a will, leaving a wife and children, the wife is entitled to, leaving a spouse and children, the spouse is entitled to 2/3 of the estate, and the children are entitled to 1/3 between them in equal shares. Now, if somebody dies and they don't leave a spouse, they just leave children, the children are entitled to inherit their estate, all of them in equal shares. People often ask the question, what happens if one of the children has died before their parent? Well, in that case, if they have children, their children inherit their parent's share in equal shares. For example, if somebody dies and their spouse is already dead and they leave 4 children and one of them has died and left three children of their own, the estate will be divided 1/4 each between the 3 surviving children and the person who's died. Their estate will be divided in 3 equal parts between their children. Now, if next in line then would be, suppose somebody dies without a spouse, without children, the next in line then would be parents. If they die and they leave parents, the parents will inherit in equal shares. Next in line would be brothers and sisters. If they only leave brothers and sisters, then the brothers and sisters will inherit in equal shares. And if any of those brothers or sisters have died, their children will inherit their shares equally between them. Now, if somebody doesn't leave a spouse or children or brothers or sisters or parents, just nieces and nephews, then nieces and nephews will inherit in equal shares, and the same rule will apply if any of them has predeceased the person who died. Now, if the person who dies doesn't leave any immediate relatives of the categories I've mentioned, the estate will be divided equally amongst their nearest relatives. In other words, if they have first cousins, the estate will go to their first cousins, second, third cousins, etc. Will have no legal rights whatsoever. It's the nearest relatives then that the estate is divided between. Now, if a person makes a will, they have to appoint an executor. An executor is the person who distributes the estate. Normally what happens is that you appoint somebody as executor and they go to a solicitor, and the solicitor, they'll distribute the estate under the guidance of the solicitor. They're obliged to pay off all legal debts and then divide the estate in accordance with the terms of the will. If there is no will, some close family member has to apply to the probate office to become the administrator of the estate, and their duties, the duties of an administrator, would be the same as the duties of an executor. They have to again distribute the estate in accordance with the law on inheritance. It can be a solicitor can usually, if a person is leaving a will and it's not very straightforward, the best advice probably is to go to a solicitor to do it for them. However, if the thing is straightforward, you can actually get a will form from certain bookshops. I don't want to advertise any of them in particular in Limerick, and you can make out the will yourself. You must have two witnesses who must witness the person signing the will, but it's a relatively simple procedure. I've done it for lots of people. In relation to taking out administration, where there's no will and you want to become the administrator of the estate, you can get some help from the court's office. You can call down to the court's office and they will give you the relevant forms and give you some guidance as to how to complete them. But they can be tricky, so be very careful when you're completing them. Now, other issues arise in relation to what happens if people are just. Now, can I just say in passing that if two spouses are actually divorced, if they're divorced by the courts, they lose all succession rights. People have asked me what happens when people don't divorce, when they get a decree, when they agree a judicial separation. Well, it doesn't arise really there, because generally speaking, in the terms of the judicial separation, succession rights will be dealt with. You're very, very often in those deeds of separation, which are mutually agreed between both parties, you will see that the succession rights have been extinguished, removed, and the two people just go their separate ways. There's also questions arising in relation to people who are living together, etc. But I will do a separate video, and I will go into more detail on that in my next YouTube presentation. So just to be clear, that people making a will, no matter, as I say, how much property they have, they're not a free agent, and they have to be mindful of the fact that their spouse has a legal right to inherit, and their children may be able to have a claim on the estate. And what I'm saying here about inheritance and wills and spouses, etc., it applies equally to civil partners. The law has been extended to include civil partners, give civil partners more or less the same rights as spouses.